All right, we're going to get started. Hello, everyone, and thank you for attending today's webinar, Layoffs, Unions, Plant Closing, and Discrimination Considerations, presented by Tim Sarsfield and myself, Colin Pajda. Before we begin, we wanted to cover a few housekeeping items. If you have any questions during the webcast, you can submit them through the Q&A widget at the bottom of your screen. We'll try to answer these during the webcast, but if a fuller answer is needed or if we run out of time, it will be answered later via email. A copy of today's slide deck is available in the resource widget. We encourage you to download any resources or links that you may find useful. You can find additional answers to some common technical issues located in the help widget at the bottom of your screen. This webinar is CLE accredited in California, Illinois, and Texas for 1 hour of general CLE credit, and in Missouri for 1.2 hours of general CLE credit. Additionally, this webinar is CLE accredited in New York for 1 hour of experienced in transition credit. This webinar is also approved for 1 hour of SHRM and HRCI credit. We award credit based on attendance for the entire 60 minutes. Due to changes in jurisdictional requirements, you will notice that we are no longer using automated pop-up attendance checks. As required, we will display secret words and multiple choice polls during the webinar. You'll be required to select today's secret word from a multiple choice list. Please respond to these polls to demonstrate your continued engagement and to earn your full credit. We value your opinions and appreciate your participation in the course. And with that, I would like to turn it over to Tim.
Hi, my name is Tim Sarsfield. I'm a partner in the Thompson Coburn Labor and Employment Practice Group. And today, Colin and I are going to be covering 4 topics, leaving some time for questions at the end. First, I'm going to talk about plant closings and mass layoffs in the union context. My comments are going to be largely aimed at private employers that are subject to the National Labor Relations Act. But if you're a public employer that is in a state where collective bargaining agreements are enforceable, much of what I have to say concerning collective bargaining agreements will certainly apply. And if you're an employer that's subject to the Railway Labor Act, again, much of what I have to say about contractual considerations will apply. After I'm done talking, Colin's going to talk about plant closing and mass layoff obligations or considerations under federal and state WARN laws, or what people commonly call plant closing laws. This portion of the topic will apply to both union and non-union employers. Then we're going to switch over to discrimination considerations, again in the context of plant closings and mass layoffs. I'm going to talk about disparate impact, which is one theory of discrimination, and then Colin's going to talk about intentional discrimination. And again, these considerations could apply to a union shop, although I do think they crop up more in the non-union setting. The severance and releases, Colin and I are going to sort of tag team that one. We're just going to talk about some common issues that arise with respect to obtaining severance and releases, and again, especially in the context of a mass layoff or a plant closing, and again, we'll leave time for questions. Okay, so let's talk about union considerations. In the area of union considerations, there's really 2 sources of consideration, or 2 sources of rights for the union and for employees. One are contractual obligations. What does your collective bargaining agreement say or don't say? What does it allow you to do? What does it require you to do? Sometimes people think, well, once I got a collective bargaining agreement, that's it. The whole world revolves around the collective bargaining agreement. And to a certain extent, that is true, but there are certain statutory obligations under the National Labor Relations Act that you always have to keep in the back of your mind. Because sometimes you don't actually have a collective bargaining agreement in place. And sometimes even if you do, you may trigger obligations under the National Labor Relations Act. Now, I'm going to be focused on plant closings and layoffs, how to handle things or things to consider. I'm not going to talk about withdrawal liability. If you're unfortunate enough to be in a multi-employer pension plan and it's underfunded. But that is always a consideration, before you do something that might trigger withdrawal liability, but that's beyond the scope of today. Next. I always think that this is just a really good practice, and this is true in the union setting or the non-union setting. Why are you doing what you're doing? Why are you closing the plant? Why are you laying off a bunch of people? Is it just for pure business considerations? For example, are you shutting down a product line? I used the word abandon. I guess what I really meant to say was, are you closing the facility? Are you moving the facility someplace else? Why are you shutting down? Maybe it's just a business downturn. We used to sell 100,000 widgets. Now we're selling 80,000 widgets. And so now we've got to do something. I do think one thing that can really impact matters is, what are you talking about doing here? Is it a short-term sort of shutdown where you're going to be laying people off for a couple of weeks or a couple of months? I think that'll be important when Colin talks about WARN. Or, maybe nothing is forever, but are we really thinking about something that is permanent here? We are going from 100 people to 50 people because of X, and we don't ever see ourselves getting back above 50, certainly never back to 100. I put subcontracting as its own little animal because in the union context in particular, if your layoff, or in particular your layoff, maybe your plant closing as a result of you subcontracting work, there may be additional provisions in your collective bargaining agreement or additional statutory obligations that may kick in over and above what might seem natural to you, like the seniority or how, what order do we lay people off. And then the final thing is are you selling your business? Now, in the union context, if the new employer has taken the CBA, for example, it's a stock deal or it's an asset deal where they're assuming the collective bargaining agreement, usually that won't create too many headaches for the seller, not really. Is the new employer taking the workforce? Sometimes they are, sometimes they aren't. Sometimes they're making huge changes in terms and conditions of employment, and that can create some headaches for the seller that the seller is going to have to give some thought to as events are moving forward. Next slide. Okay, contractual considerations. The very first question you ask yourself is, do I actually have an active collective bargaining agreement? And by active, I mean, are you in the course of its original term? All right. Is the contract from 2020 to 2025, and now it's 23 or 24 when you're doing this, or before it expires in 25? Sometimes contracts roll over. Most collective bargaining agreements have a provision that talk in terms of, if one side or the other doesn't notify the other that by X date they want to negotiate a new contract, the contract rolls over. Sometimes what will happen is, when you're negotiating a collective bargaining agreement, you'll be coming up on the expiration date, and the parties may agree to extend the contract. Now, you don't always extend the contract. There's reasons to extend a contract. There's reasons not to extend a contract, but sometimes you are dealing with an extension situation. Why you would extend or not extend, again, sort of beyond the scope of today's presentation. Sometimes, though, you're dealing with an expired contract. Okay, so the contract expired on December 31st, 2022. And now it's the late March of 23, and you don't have a new contract, and you didn't extend it. So what happens then? One thing that I always encourage HR people and legal to make clear to their business people, because sometimes business people get confused about this. They're like, the contract expired, it's gone. I don't have to worry about the contract anymore. It's the Wild West out there, or it's Katie bar the door, and that is not true. You have a statutory obligation under the National Labor Relations Act to maintain most terms and conditions of employment that were found in the old contract pending negotiation or agreement on the new contract, or until you get to the point where you make a last, best, and final offer because you're at legal impasse, and then you can go ahead and implement some or all of your last, best, and final offer. So, if there are provisions in your contract that touch upon layoffs, and there almost certainly will be, I can assure you of that, those conditions remain in effect after the expiration date, unless or until you get agreement from the union that new layoff provisions are in place, or you had something dealing with layoff in your last, best, and final, you're at lawful impasse, and you can lawfully implement those changes. An important thing to understand is certain terms do die with the contract. Now, usually you think about that as things that bother the union. For example, union security, the concept that you have to join the union to keep your job, that dies with the contract. Usually the union likes the arbitration provision. That normally dies with the contract, or pretty much dies with the contract. The one thing that sometimes companies lose track of is your management rights clause also dies with the contract. And sometimes the only place in your contract where it says, well, I can shut down, or I can move, or I can lay people off is in your management rights clause. So you want to be sure in the expired contract situation that you have a firm grasp on how much am I relying on my management rights. And I'll talk a little bit about other things that you might consider if you have an expired management rights clause. In particular, what is your past practice with respect to layoffs or moving work out of the plant? Next slide. Then there's the first contract situation, and this I'm actually dealing with a situation like this. The company got organized. They're in the middle of negotiations for a first contract, so there's no contract in place. And now people higher up above the plant level, they're engaged in a big layoff across the company, union and non-union plants entirely, and they want to lay some people off at this plant. Well, to the extent you're talking about represented employees, what do? Well, because they now have a union, you're probably going to end up having to bargain how you go about laying off people for sure. Again, unless you were at some sort of lawful impasse. So at that point, for sure, statutory obligations will kick in under the National Labor Relations Act. Okay, typical contract consideration. Make sure you read the actual collective bargaining agreement. I know that sounds like, well, duh, but you'd be surprised how often I talk with people and they will be asking me questions about, hey, we're calling you because this involves some union employees. And I'll say, what does your contract say? And they'll say, well, I don't know, it's just the standard union contract. And that's not how it works. All union contracts are different. And in the union context in particular, past practice is important. Well, have you had layoffs before? What did you do in those situations? Now, it may be, well, since our last layoff, the contract has been modified, but a lot of times the provisions that you're reading in the contract are interpreted in light of, well, what is the past practice? Next one. Okay, so what are the sorts of things that you look for in the collective bargaining agreement? Well, can you do it? I mean, normally an active collective bargaining agreement is going to allow for layoffs and plant closures, but occasionally there's exceptions. I mentioned subcontracting. Now, this is very common in collective bargaining agreements. Is there some express limit on your ability to subcontract? So it'll be separate and distinct from matters that deal with layoffs. It's an actual, hey, before you subcontract, you got to notify the union and maybe bargain with the union over the subcontracting decision. Or it may say, hey, you can subcontract work, but you can't lay anybody off as a result of the subcontracting. Or it may say you can't subcontract work if you got guys out there on layoff. So you do have to pay attention to your subcontracting provision. As I said, if the contract expired or you don't have a contract in place, you're going to want to know Well, did my right to lay off or close survive contract expiration? Notice provisions are somewhat commonplace in union contracts. You may have to give notice of a job action even if warrant is not triggered. I've had that situation come up before where people want to know, well, do I have to give a notice under warrant? And the answer is no. And then I'll casually answer, well, do you have any union employees? And they'll go, well, yeah. Well, what does your contract say? And there may very well be, you've got to give a week or 2 weeks or 30 days notice. In the sales, I just went through something like this. Sometimes you have to give notice of the sale to the union. So you're going to want to know, what does your contract actually say on this topic? Then there's the selection process. Who's actually going to get laid off, or how are you going to go about laying them off? Seniority plays a huge role in collective bargaining agreements, but you want to make sure you know how at that particular plant or under that particular contract, how is it calculated? When does it kick in? So is it kick in, or excuse me, is it decided on a plant basis, department basis, a job classification? What role does it play? There are still a few union contracts out there where it's pretty much strict. If you're laying off 20 of your assemblers, you're just doing it. First, you get rid of your probationary employees, and then you just start rolling up. Your least senior guy goes out the door first, and then your most senior guy stays. So, for example, if Colin and I worked for you, Colin would be a much better employee than me, but I'd have a heck of a lot more seniority. So you'd have to keep me and get rid of him. Okay. Other times it talks in terms of skill and ability, but seniority still plays a role. So you want to make sure you have your arms around, well, what kind of a role? Is it a tiebreaker? If Colin and I have similar skill and ability, is that when my seniority kicks in? The seniority govern unless Colin clearly has more skill and ability than I do. And when you're doing that analysis where skill and ability plays a role, you need to decide, well, A, how do you decide what skill and ability actually really means? Sometimes it's spelled out. Sometimes you have to look to past practice, and you have to look at, well, whose burden is it? Can you just say, well, Colin's got more skill and ability, and the union has to show that that determination was discriminatory or arbitrary and capricious or something else? Or if you say Colin's got more skill and ability, you got to prove it in front of an arbitrator. So you want to know that. Something that I see sometimes is it'll just say skill and ability and seniority will all be considered. So what does that mean? Exactly. Well, a lot of times past practice will answer that question. Sometimes maybe there is no past practice, then you look to bargaining history, or you just take a shot with the arbitrator. You probably are going to have to give seniority some consideration. One other thing to get your handle on is sometimes when you're laying people off, there's bumping. So you may be laying off your two most junior welders, but then they may have a right to bump junior employees in other classifications or in other departments. So you're going to want to know, well, how does that work? Can they just bump anybody? Do they have to have the skill and ability to do the job? How much skill and ability do they have to do the job? And again, past practice can tell you a lot about that. The next thing that you want to have your arms around is, how does recall work? In the union setting, a lot of times people will talk about floating for recall. And one difference between, I think, a layoff in the union setting and the non-union setting is, in the non-union setting, when you tell somebody they're laid off, what you're really saying is you're fired, but it's not your fault. But if you want to come back here, you're going to have to reapply. In the union setting, if you get laid off, usually you float for recall for some period of time. Commonly, it's 12 to 24 months. Could be longer, could be shorter, but that's kind of common. And then you have to make sure you understand, well, how does the recall process actually work? Who has what responsibility? Something that can be very important that's spelled out in a contract is, it may not simply be a matter of, well, I'm going to call Tim on Friday and say, be back to work on Monday if you want a job. You may have to give me a couple of weeks before I'm back. So you want to have a handle on how the recall works. Occasionally, but not always, a union contract will actually spell out some sort of a severance. In particular, if you're closing the plant or if you're talking more of a permanent layoff as opposed to just a seasonal look, business is a little bit soft right now, we'll probably be calling you back in 2 or 3 months. Again, just because the CBA has expired doesn't mean it all goes out the window. And what about those first contract negotiations where you don't have any of that? And this is a good time to switch to statutory obligations. As I stated, generally maintain terms and conditions of employment, but sometimes you have to engage in what's known as effects bargaining, and sometimes you have to engage in decisional bargaining. Effects bargaining is where you actually bargain with the union about, and you may have to bargain with the union over effects, even if you've got a collective bargaining agreement. Like, how do we alleviate the impact of this on the employees that are being laid off? Decisional is not only how do I go about laying people off, but can I lay people off? All right. I put this under effects. Something that'll happen, especially in a shutdown, is it may take you 60 or 90 days to lay the place off. And the people aren't stupid. They're going to notice that machines are getting moved out or work is disappearing. So you may want to negotiate a shutdown agreement with the union where you discuss, well, what's the incentive we're going to offer people to stay. In a non-union context, you can just do whatever you want to get people to stay. In a union context, you have to negotiate that. How are we going to roll up the operations? You know, sometimes what you're doing is you're shutting down departments, and especially in the bumping thing, you don't want people constantly bumping as they're getting laid off from departments in order to be the last man off the sinking ship. So you negotiate with the union, no, we're going to waive bumping in this particular situation. Another thing that unions will be interested in is what happens if you reopen the place. But other impacts that you negotiate, are severance, healthcare, reference, transfers. If you are shutting down a plant in the city of St. Louis and you got another plant, 30 miles across the river, the union may want to talk with you about how people transfer to that plant, or at least get put on a a preferential hiring list. You don't necessarily have to agree to it, but that's something you will talk about next. Again, now, especially like in that first contract situation, occasionally, depending on how your contract is written, you may actually have to negotiate the decision itself. Normally, the key question there is, well, how much of a role does labor cost play in the business decision? If it plays a role, you're probably going to have to end up negotiating the decision itself. Sometimes it's got nothing to do with labor costs. Sometimes it's literally, we want to get out of California. We can't, the taxes are too high, it's not friendly enough. We're just moving. Another thing that can happen is, labor costs matter, but in order for us to stay, you'd have to agree to minimum wage, and we wouldn't accept it if you offered it to us. Why? Because nobody would come to work for us. Again, if there's no contracting, if there was never a contract existing or expired, probably going to negotiate the how. What role will seniority play? Probably should have talked about this in a first contract particularly. Make sure that people aren't making this decision to do the layoff because they're upset because they lost an election or because the people chose a union. Make sure you're doing this for legitimate business reasons. Next.
All right. Now we have our first secret word, which is consideration. Please select the correct word below. We'll give you about 30 seconds here. Repeated, today's first secret word is consideration. All right. Got another 10 seconds here. Secret word is consideration. Excellent. Okay, let's move on. So now we're going to talk about the WARN Act. considerations with the Federal WARN Act and also state WARN Acts. So the WARN Act is essentially a notice act. It requires employers to give employees and other stakeholders notice in advance of plant closings and mass layoffs. And we'll talk about what those terms mean in the statute in a second. Now, some states have what we call mini WARN Acts. These are also notice acts that require, maybe additional requirements for notice, who gets notice. Many of them have lower triggering thresholds or lower thresholds for who's a covered employer. So in these states, the employers are going to have obligations under both the Federal WARN Act and the State WARN Act. We're going to talk about 3 states at the end of this section, but it's always very important to know when you're doing these things that you check with your state to make sure that you are not covered by a separate state mini WARN Act. So what is included in a WARN Act? We have things that talk about who is a covered employer, what kind of events trigger notice duties under the law. Does that mean a certain number of employees are terminated within a certain period? Required notice. Who does the notice need to be given to? How far in advance does notice need to be given? And what needs to be included in the actual notices? And that varies significantly depending on who the notice is to. Some of these statutes, the federal statute, also includes things like exceptions and, of course, penalties. No statute is complete without a penalty. We're going to go through each of these categories right now for the federal law. And then at the end, we're going to talk about where some of the states differ. So covered employers, who has to comply with the WARN Act? I said that the WARN Act is a notice act. It's also very much a counting statute. The WARN Act is all about how you count employees, how you count days, how you count months. So to be a covered employer under the Federal WARN Act, we're looking at either employers with 100 or more employees, excluding part-time employees, or employers with 100 or more employees, which includes part-time employees who collectively work at least 4,000 hours of straight time each week. So that 4,000 hour requirement does not include overtime, right? So we're only talking about straight time. For the statute, a part-time employee is an employee who either works an average of 20 hours or less each week in the last 90 days, or has worked fewer than 6 of the last 12 months prior to the notice date. I told you it's all about counting, right? So we're constantly counting. So we have 2 triggering events for the federal statute. The first is a plant closing, and this is a permanent or temporary shutdown of a single site of employment, resulting in employment loss for at least 50 full-time employees during a 30-day period. We're going to talk in a minute about what that means, single site of employment and employment loss. The other triggering event is a mass layoff, and that's any kind of reduction in force that is not a plant closing, right? So it doesn't come in under the plant closing, and results in the employment loss at a single site of employment during any 30-day period for either 50 full-time employees who make up at least 30% of active employees, or at least 500 full-time employees. So, an example of the first requirement, the 50 full-time employees who comprise at least 33%. Say you have 175 employees at a site and 50 are laid off. There's no WARN trigger here, no federal WARN trigger, because even though you got to that 50 employee threshold, they make up less than 33% of your total 175. So when the statute talks about a single site of employment, that can mean a few different things, right? It can mean a single location, right? Or a group of adjacent locations, right? You've got a building or a group of buildings on a campus. So groups of structures forming a campus, an industrial park, or separate facilities maybe across the street from one another. Those can all be considered single sites of employment. Occasionally, you'll also get separate buildings or areas that aren't directly connected or in immediate proximity, but they can be considered a single site of employment if they're in reasonable geographic proximity, share the same staff and equipment, and are used for the same purpose. So if you have two, facilities that are a 5-minute drive from each other, and they do these things, they share the same staff and equipment, and they are used for the same purposes, that can be considered a single site of employment. Employment loss, it can be, when we're talking about the Warren statute, any kind of employment termination other than a discharge for cause, a voluntary departure, right, a resignation, or a retirement. A layoff exceeding 6 months. So if you are anticipating laying off or furloughing a portion of your workforce for 8 months, you have Warren requirements if you meet the other requirements. And a reduction in work hours of more than 50% during each month of a 6-month period. So if you're going to be taking everyone down to less than 50% of their normal working hours, and that's going to extend over a period of 6 months, then you may have Warren requirements. There are a few timing issues. We have a 90-day aggregation rule. And this means, when you're planning a plant closing or a mass layoff, you should be looking at the 90 days before and 90 days after the planned event to consider planned and completed employment losses, right? This requirement ensures that employers aren't going to use small layoffs over a short period of time to get around giving Warren notice. So if the aggregated employment losses trigger Warren Act, then you might have notice requirements. There are some exceptions if we can say that they are absolutely different circumstances resulting in each, but generally you're going to have Warren notices there. There's also a 30-day window rule, and this means that if you have Warren triggered and you're giving notice to employees, all other employment losses within the 30 days of the event are aggregated with it, requiring notice even for non-plant closing and mass layoff employees. So if you were terminating an employee for cause and it's in the same 30-day period as a mass layoff or a plant closing, you also have to give those employees Warren notice in most circumstances. Okay, so now we're going to get into what the notice requirements actually are. So for Warren, you need to give notice 60 days in advance before the plant closing or mass layoff, and you need to give notice to the union representative of each affected employee if you have a unionized workforce, each affected employee individually if not represented by a union, the state dislocated worker unit or office or state entity designated to carry out rapid response activities. And this is essentially so the state's unemployment division isn't overwhelmed by claims, right? They know ahead of time that all of these claims are going to be coming, and so they can prepare for an influx of claims and get prepared to help people move into new jobs. Also, the chief elected officials of the unit of local government where the closing or layoff will occur. Similarly, this gets them notice to plan for the fallout of a plant closing or a mass layoff. The content of the notices varies, sometimes significantly depending on who the notice is for, right? So whenever you're preparing the notices, you need to work with your attorney to make sure that each notice has the content required for that particular party who's getting the notice. What a union rep gets is different than what the chief elected official of a local government gets in terms of notice. There are also a few exceptions to the notice requirements. For example, if a plant closing affects only a temporary facility, a facility was open for a set short period of time to handle particular work with the understanding that the facility would be closing after that time, Warren notice isn't required. If a closing or mass layoff occurs because a particular project or undertaking is completed, and the employees who are going to be affected knew when they were hired that their employment was limited to that project or undertaking, Warren notice isn't required. And then a plant closing or mass layoff that constitutes a strike or a lockout, right, which is not otherwise meant to evade the Warren Act. So I see we have a question asking what are some examples of chief elected officials of the unit of local government? What does that look like? Oftentimes that can be a mayor of the town or city where the plant is located.
Or if you were in unincorporated St. Louis County, it would be what, the chief executive?
Chief executive, yeah. Right. The notice period can be reduced in some circumstances if you meet these different exigent circumstances. So if you have a faltering company who is trying to get together funding, giving notice might hurt their chances of securing the funding they need to stay open. You can reduce notice there. If there are unforeseeable business circumstances or if there's a natural disaster. Now, it's important to note, however, in these circumstances, you aren't exempted from giving notice. You just have to give the notice that is practicable, right? So as soon as notice is able to be given, you need to give it, even if it's going to be less than that 60 days. And often when you give that notice, you need to say why the 60-day period was not doable, right? You need to show that you had a faltering company circumstance, a natural disaster circumstance that exempted you from giving the full 60 days. Also, when we're looking at penalties, so when we're looking at penalties, right, the Federal Warren Act creates two main things for employees. The employees will get back pay for each day of the violation. What that means is if you were required to give 60-day notices and you gave 30-day notices, you might be required to pay the employees for that 30 days they didn't have notice for. Similarly, you might be required to pay for their benefits, right? Including, and this can be sometimes significant, the cost of any medical expenses incurred during the employment loss that would have been covered by a benefit plan if you haven't given the full notice, right? So if during that 30-day period where you were supposed to but haven't given notice, someone incurs a significant medical expense, you might be on the hook for that. In lawsuits meant to collect back pay and wages for employees who were not given proper warn notice, courts may also order attorney's fees to be granted. So now we're going to take a look at 3 states, California, Illinois, and New Jersey, to see how their state WARN Acts differ. Missouri does not have an individual WARN Act, so we just comply with the federal law here. So California, the first thing we see is that the requirements for being a covered employer are lower, right? You need to own an establishment with at least 75 employees in the preceding 12 months. So we're already lower than the 100 that the federal WARN requires. And with everything we talk about in the state issues, that means that you may have state WARN requirements, for California, even if federal requirements aren't triggered, right? So you always need to be considering which statute is triggered. Is it both? Is it neither? Is it only one? For triggering events, we have 3 in California. A mass layoff, which is 50 or more employees at a covered establishment during any 30-day period. A relocation, which is common in state plant closing laws, many WARN Acts, which means that you're taking business at a facility and you're moving it to a different location 100 miles or more away. Also plant closing, so termination of industrial or commercial operations in a covered establishment. For penalties, normal WARN Act penalties, including back pay and back benefits. However, California also imposes additional civil penalties. So in addition to paying the employees, you're going to be paying the state of California. Now, New Jersey recently passed a update to their WARN Act that takes effect on April 10th. And so these are the upcoming April 10th requirements, right? So now a covered employer is anyone with 100 or more full or part-time employees, right? And there's no 4,000 hour requirement in the new iteration of the statute. Triggering events, mass layoff is a reduction of force of 50 or more employees within 30 days, no percentage requirements. A termination of operations, which is a permanent or temporary shutdown of a single establishment, resulting in termination of 50 or more employees within 30 days. And similar to California, a transfer of operations, which can be a permanent or temporary transfer of a single establishment to another location inside or outside the state of New Jersey, affecting 50 or more employees within 30 days. The most significant change is now there is statutory severance required. So in New Jersey, if the New Jersey Mini Warren Act is triggered, you must provide 1 week's pay for each full year of employment for affected employees. And unlike the federal statute, which is a 60-day Warren notice requirement, the new New Jersey statute has a notice of 90 days. We don't have I think Illinois got left off here on the slides, but we'll go through Illinois quickly. So a covered employer for the purposes of Illinois means 75 or more full-time employees or 75 or more employees who work at least the 4,000 straight hours per week. Triggering events are plant closings that result in an employment loss of 50 or more full-time employees, right? So that's the same as the federal. The difference here is with the mass layoffs, which is a reduction in force that results in employment loss at a single site of employment to 25 employees who comprise at least 33% of full-time employees or 250 full-time employees. You'll remember the federal act was 50 full-time employees who are at least 33% or 500. So the requirements for the Illinois mass layoff triggering event are significantly lower than the federal statute. And like California and New Jersey, relocations of operations also qualify as WARN notice events. And under penalties like California, there are additional civil penalties for violations of the state WARN Act. And now we're going to turn it over to Tim to talk to us about disparate impact discrimination.
There were a number of questions about severance agreements. We're going to be getting to that later in the presentation, how the Older Workers Benefit Protection Act works. And I'm going to discuss briefly a recent board case that appears to put restrictions, at least in some cases, on severance agreements or on common clauses in severance agreements. And then there was a question, how did COVID impact companies giving WARN notices? Some just gave the 60 days. Some took advantage of, well, you got to be off 6 months before it's considered an employment termination. So they'd be calling back people or enough people at 5 months and 28 days to avoid having a plant closing or a mass layoff. Some employers are just slugging it out right now, arguing that this was unforeseen business circumstances. How did I know that the county executive was going to shut down my business and or some sort of a natural disaster?
And some states also suspended their WARN acts temporarily kind of during the height of the pandemic, but I think they have all been restarted.
Yeah. All right. In terms of discrimination considerations, I'm going to talk about disparate impact. Okay. In a disparate impact claim, motive does not matter. It doesn't matter whether in whole or in part you're trying to get rid of women, or you're trying to get rid of people over 40, or you're trying to get rid of Irish Catholics for that matter. It's your selection criteria, whatever it is. It may be entirely neutral on its face and evenly applied, but it has a disproportionate impact on a protected class. So a real simple example, I don't think anybody would do this, but a real simple example would be if you just said, I'm going to lay off everybody in the company that's shorter than 5'10". That's facially neutral, and you get rid of every single person who's below 5'10". You will be getting rid of a certain number of men, but on balance, you're going to be laying off far more women than you are going to be men, because certainly there are women that are 5'10" and above, right? But on balance, that's going to have a disproportionate impact on women. So how do you decide whether you got a disparate impact or not? Well, there's the 80% rule, which plaintiffs' lawyers like and which the EEOC likes, but courts don't always accept, versus more sophisticated analysis. Next slide. Okay, so what's the selection, the 80% rule? It's a selection rate for any given group, say males, which is less than 80% of the rate for the group with the highest selection rate. If it's less than 80%, that will generally create an inference of discrimination. So if you had 125 assemblers, 100 were male and 25 were females, and you laid off 35 males and 10 females, you're laying off about 35% of your males and 40% of your females. 35%, you're basically laying your males off at about 87% of the rate at which you're laying off females. So that's not a problem. That doesn't violate the 80% rule. If you change that and you're only laying off 25 males, you might say, well, I'm still laying off more males than females. I'm laying off 2.5 times as many males as females. But now the rate at which you're laying off males is 63% of that rate at which women are being laid off. So you got an adverse impact. Now there's more sophisticated, there's even more than what I put up here, but two that I like to look at is chi-square and 2 or more standard deviations. So if it was the same as the last example and you ran those tests, there is no disparate impact. Although again, if you dropped it again down to 20, even though you're still laying off more males, even though it's twice as many males, now you're going to start hitting disparate impact, even under the more sophisticated tests. So how do you calculate? How do you do 2 standard deviations? Well, if you're a statistics major, you probably can do it in your sleep. I'd like it if you hired me. Now, to be honest with you, what am I going to do? Well, I'm going to Google disparate impact calculator. Then I'm going to go down to that site, and whatever information you give me, I'm going to plug into the calculator. Now, there is a reason why you do want to probably get lawyers involved when you're doing these calculations, whether it's your in-house counsel or your outside counsel, or at least get direction from a lawyer to do your calculations so that you can keep it privileged as long as possible, all right? Now you do normally want to do your disparate impact calculation for gender, race, and age. You don't see it so much for religion or other protected characteristics. Those are kind of the big 3 in terms of doing your calculations. Next slide. Okay, what are some of your defenses? Well, this may have had a disparate impact, but it's job related and consistent with business necessity. The test is worded slightly different for age. In any case, the plaintiff can try to show, well, yeah, but consistent with it being job related and consistent with business necessity, if you'd done this, it wouldn't have had as great an impact on this protected class or that protected class. Something that I think people lose sight of a lot of times is, small sample sizes will give you bad results. Okay. I mean, I'm going to assume that most of the people on this call here today are baseball fans, maybe Cardinal fans. If a guy goes 4 for 10, okay, he's batting 400. Nobody's going to say he's batting 400 for the whole season. It's too small of a sample size. Well, it's the same thing in this situation. Sort of a rule of thumb that the OFCCP has adopted is, you need to have about 30 people in your decisional group, at least 5 of whom are minorities, and at least 5, terminations. If you're doing sample sizes smaller than that, your numbers really aren't very reliable. And even there, that's just a rule of thumb. I mean, you may always want to argue this is just a really, really small sample size. And sonority is almost always a good defense. Like we just did this in straight sonority. So that's another defense. Next slide.
Okay. So reductions in force can also be the catalyst for disparate treatment claims. And as opposed to disparate impact, which relies on neutral criteria, disparate treatment is your traditional intentional discrimination against an employee because of a protected characteristic or because the employee engaged in protected activity. They complained about discrimination previously, they engaged in whistleblowing, and now they're being terminated for that reason. So when should you be concerned that you might be subject to a disparate treatment claim based on a reduction in force? Here's kind of a little scenario. you ask a manager who has 30 employees to choose 5 employees to include in a reduction in force. Okay, so in the first situation, the manager chooses 4 to 5 individuals who all have the same protected characteristic. So that's a red flag. If a manager chooses 4 to 5 individuals who are all part of different minority groups, and the 25 employees who are remaining are all not part of those groups, that's a red flag. A manager chooses an employee who has made a recent complaint of discrimination or retaliation. That's a red flag. Those things don't mean that you have discrimination going on, of course. There are probably, valid, neutral reasons. However, that's when we need to be making sure that we're covered, that we're defended, that we can give a reason for these things. So what do you do, when you have these red flags going on? So to protect the company, the first thing you want to do is meet with your decision makers before decisions are made. You want to talk to them about what criteria that the company wants to use, what they need to make sure, they have in documentation or, just in HR files, right, to support the decisions they make. You want to have these discussions before the layoffs occur. It sounds obvious, but it's much easier to pull all the information together before you lay the people off than once they're laid off and you're being faced with a demand letter from opposing counsel. So don't wait until after the reduction before you start questioning decision makers about how they chose certain employees. And third, to the extent possible, you want to verify that your manager's choice was based on an objective, articulable criteria. Tim just talked about great neutral metrics like seniority. Now, of course, you need to be aware, as Tim said, about disparate impact with seniority, but that is a neutral criteria, right? That if that's the basis, you probably don't have intentional discrimination. Most often, however, when we're choosing employees for a reduction, we're talking about performance, right? What are the employees who have the lowest performance? But if a disparate treatment claim is brought against the company on these employees' behalf, we need to do more than just say the employee's performance was poor, right? We want to have objective indications of poor performance compared to employees who are not selected. For example, hopefully we have some bad performance reviews, we have a few corrective actions, we have objective performance or production metrics, or even things like some emails, some coachings that we can say, this employee who was chosen, their performance was worse than someone who was not chosen. That shows a neutral reason for selecting them. Okay, we now have our next secret word, which is benefit. Please select this correct word below. Again, the secret word is benefit. We'll give you a few seconds for everyone to select that. Okay, 5 more seconds. Benefit. Excellent. Okay, so now we're going to talk briefly.
There was a question about, what about other protected groups, religion, gender identity, or national origin? That was by way of example. I will say that a lot of times national origin ends up getting swept up under the, the race side of it. To begin with, on the religion side, I don't know. I can foresee that maybe you might have a situation where you have a pretty good handle on what everybody's religion is or is not. And, in most cases, I don't even know that you would have, that information. I don't know. What do you think? We got 50 people in our department all scattered around. Okay. I'm Catholic. I know a few other people are Catholic. I've got some friends that I know are Jewish, but I would say the vast majority of people, I don't have a clue. Actually, I know this guy's Irish, but I don't have a clue what his religion actually is or is not. And gender identity, I guess maybe you might have some clue, but I don't know that you would be able to get up to anything meaningful in terms of a sample size. Now, it might vary from employer to employer, but that's my thought on that. subject.
Yeah, absolutely.
So,
Okay, so now we're going to talk briefly about two kind of big issues right now in severance and release agreements. So when you have a reduction in force, normally you're going to want to offer some sort of severance in order to get a release agreement, right? Now, many of you are probably familiar with the Older Workers Benefit Protection Act and what it requires for release agreements that include age discrimination releases for employees over the age of 40. So kind of traditionally, they get 21 days to consider the agreement. After they sign it, they have 7 days to revoke. There's other requirements, the language must be readily understandable, etc. However, when you're getting releases from employees over 40 in the context of a reduction in force, there are some additional requirements, right? So now the 21 days is 45 days to consider. They still have their 7 days to revoke. And this is the big one, which can be, onerous in some circumstances. You need to provide a list of employees in the relevant decisional unit, which we'll talk about in a second, with their position titles, ages, and whether they were chosen for the reduction in force. You don't include names with that. So what you'll see is a spreadsheet, basically, that says position title, age, and then a column that says, terminated, yes or no. And that's for the decisional unit. Now, what is a decisional unit? The basic definition is it's the portion of the organizational structure from which an employer is choosing who will be laid off and offered a release, right? Often this can be a specific facility, a division, reporting structure. Say you're laying off 10% of the people that report up to the vice president of marketing, or specific job categories. You want to get rid of 10% of your administrative staff. However, identifying a decisional unit that is too broad or too narrow can result in an invalidation of the release. It's a very tricky concept to pin down, and one that you should absolutely discuss with counsel before issuing a release agreement that includes information about a decisional unit. Now I think we're going to turn to Tim, who is going to talk to us about some recent issues in severance agreements.
Yeah, and I think there's been some questions as we've been going along about this. And I'll get to that case in a minute here. If you do have union represented employees and you're doing a layoff and a shutdown, and for whatever reason you want to get a release from individual employees, you need to negotiate the terms of that agreement with the union. That was one of the things that the employer did wrong in McLaren and Macomb. They just put a severance agreement out there and they never even talked with the union about it. As a practical matter, unions sometimes are reluctant to agree to broad waivers, of statutory rights or, common law retaliation claims, because there are a lot of times the business agent is, I'm not a lawyer. I can waive rights maybe under the National Labor Relations Act. I can waive rights, under the collective bargaining agreement, but I'm a little concerned about waiving age stuff. Now, there's a way you can get around that. One way of getting around it is to say, fine, I'm willing to give 2 weeks severance to everybody for what you're willing to waive. I'm willing to give a lot more for a broader waiver. One thing that you do want to do in severance agreements, whether you're union or non-union, and this ties back into McLaren, usually in a release, you'll have some language in there about how the lad can go down and file charges with the EEOC or cooperate with the EEOC. We'll spell out that they can do the same thing with the National Labor Relations Board. The National Labor Relations Board, sometimes they feel unloved. And so they like to be treated with the same respect, or what they view as the same respect as the EEOC. I think these questions are dealing with this McLaren versus Macomb, which was a board case that said, at least with respect to employers that are subject to the National Labor Relations Act, it's possible that your non-disparagement clause and or your confidentiality clause is an unfair labor practice. Merely proffering it to them with too broad of a non-disparagement clause is an unfair labor practice. And maybe some of what's in your confidentiality clause is a unfair labor practice. Next one. Okay, now that case applies to non-union employee. It says employees, but I guess I should really say non-union employers subject to the National Labor Relations Act. So that's most private sector employees or employers. There's carve-outs for 211 supervisors and or managerial employees. Before you label somebody a supervisor, a 211 supervisor, that's from the section of the Act, or a managerial employer, you might actually want to talk with your favorite labor and employment counsel. It's not as simple as saying exempt managers are different than saying that somebody's professional too. On the non-disparagement side, what raised the board's ire was they had a kind of a standard non-disparagement clause that said, you won't say anything bad about the company, period, or about anybody associated with the company, period. Okay. So if you were to say, you know what, I thought it was kind of a crappy place to work. They worked you too hard and they didn't pay you too much. You violated that non-disparagement clause. The board thinks that's too far. They think employees have a right to criticize their former employer's terms and conditions of employment. There's two ways that I think that you can get around that. Number one would be, the board draws a distinction between them disparaging terms and conditions of employment versus disparaging your services or products. So you could just put in there and say, you won't say anything disparaging about our products or services, and hope it gets lost in the shuffle. You can always say, now this is kind of funny, the board doesn't like you to say, don't make defamatory statements about the company. They would rather have you say, don't make maliciously false or maliciously untrue statements about the company. The bit about the way the case read was the employees were prohibited from talking about how much severance they got. Now, in a union setting where you've negotiated the severance agreement with the union, I don't know why you would do that. Everybody knows what everybody got because they voted it. They know that you got 1 week severance for every year of service up to a maximum amount. And everybody's got a pretty good idea of, well, Tim's got 30 years and I don't know, what do you got? 5, 10, 5. Okay. So everybody can do that calculation. It may be the same even in a non-union setting, that you've got a formula that everybody knows. I don't know that you actually, need it, where you're doing different amounts. One thing that might fit into the board's own practice is, although this doesn't entirely square up with the case itself, but the board's own practice has been in settlement agreements. You can put in a deal that says, I won't disclose the amount. I'll just say, yeah, I got a severance and I signed a settlement agreement and I'm satisfied. But you don't get to say, well, I got 10,000 or I got 100,000 or I got whatever. I think with that, we are past our hour, so you can all get your accreditation. I don't know if there's any more questions that we haven't answered.
Like we have.
Oh, this is a question about why would you bother to extend a collective bargaining agreement? Well, there's two reasons why you might want to extend a collective bargaining agreement. The first of which is that extends the no strike clause. You may not want the union walking out on January. Second, another reason is you may actually want to keep the arbitration provision, for example, in And by the way, going back to the strike is just because the contract expires on January or December 31st doesn't mean that the union either strikes January 1 or the first business day or it waives its right to strike. Sometimes you want to extend it because we're a long way from getting to a contract. And our busy season is coming up at the end of January. We don't want the lads walking then. So that would be why you would want to extend it. And sometimes you just actually kind of like, let's have an arbitration provision so that if disputes arise, we can handle it the way that we're used to do it without people running off and hiring private lawyers to try to sue us. You're going down to the board and filing charges. So I think that would be a reason why you might want to extend it.
Great. I think that's the end of our presentation. Thank you for participating in our webinar today. Please complete and submit the survey that will display at the conclusion of the webinar. Thank you.